This portion of the training will cover other laws and executive orders that FEMA's environmental and historic preservation staff are required to consider as part of the review process. Please note, separate training modules for NEPA and the National Historic Preservation Act exist, and this module will not delve into those two laws. My name is Tanner Adamson. I'm a Supervisory Environmental Protection Specialist in the Region 3 Philadelphia office. Now let's get started. Anytime federal funding is used, environmental and historic preservation laws, regulations, and executive orders are required to be considered. In the case of FEMA, environmental and historic preservation staff carefully review each project for compliance and issue a record of environmental consideration, or REC, to approve each project before funds are released. Sometimes this can occur relatively quickly, but other times consultations with regulatory agencies or even an environmental assessment may be required. Here's a list of the additional laws and executive orders that EHP is required to consider in addition to NEPA and NHPA. While not exhaustive, this shows the main laws we review for compliance for each project. The list on the left shows laws and executive orders that FEMA projects are more likely to affect, including the Endangered Species Act, Clean Water Act, and executive orders for floodplain management and wetlands. The list on the right details a variety of other laws that may be triggered, depending upon the nature and location of the project. EHP staff will look at each of these laws and executive orders when reviewing projects from any FEMA grant program in an effort to mitigate impacts to environmental and cultural resources while also ensuring compliance. The Endangered Species Act is one of the most common laws when it comes to FEMA-funded projects. The goal is to protect threatened and endangered plants and animals, which requires preserving critical habitats and mitigating potential dangers to their survival, as well as recovering and maintaining the species who are endangered. When EHP staff complete project compliance reviews, our job, under Section 7 of the Endangered Species Act, is to consider and determine if an action has the potential to affect listed species or their critical habitat within a project area. Projects that are most likely to consider an Endangered Species Act consultation include new construction or any type of ground disturbance, work in water, and the removal of debris or trees from the project area. If there is potential to affect, FEMA is required to consult with the U.S. Fish and Wildlife Service, or NOAA, depending upon the species. U.S. Fish and Wildlife Service for terrestrial and freshwater species, and NOAA for marine species and anadromous fish. Sometimes species surveys may be required to determine if a listed species is present on the specific project site before work can commence. If a species is present in the project area, conditions are placed to help avoid or mitigate impacts as much as possible. It should be noted that the Endangered Species Act applies to everybody, not just federal agencies or projects. Next up is the Clean Water Act of 1972, which succeeded the Water Pollution Control Act of 1948. The Water Pollution Control Act was the first major U.S. law to address water pollution. Growing public awareness and concern for controlling water pollution led to sweeping amendments in 1972. And as amended in 1972, the law became commonly known as the Clean Water Act, which shifted protection from reliance on violations to a permit-based system. The purpose of the Clean Water Act is to maintain and improve America's water resources by establishing water quality standards that limit pollutant discharges. For each FEMA project, EHP staff must determine if work in or near water or wetlands will occur, and if so, coordination with the U.S. Army Corps of Engineers or state environmental agencies may be necessary. In addition, some actions may require a permit from one of these agencies to work in water or discharge pollutants, and your regional EHP staff members can help guide you through the process. Applicants must coordinate with the U.S. Army Corps of Engineers and the state agencies to obtain the appropriate permits before beginning any work in water. FEMA activities that are most likely to impact water resources include culvert replacements, bridge repairs, drainage improvements, and embankment restorations. The next regulation we'll look at is Executive Order 11988, which addresses floodplain management. The primary goals of this executive order are to maintain natural and beneficial floodplain values, evaluate effects of federal actions in floodplains, and avoid development or new construction in floodplains wherever there is a practicable alternative. In particular, it is inadvisable to place critical facilities such as hospitals or fire stations in a floodplain due to the risk and potential loss of function in the case of a disaster. Development in the floodplain may also require public notice and the solicitation of feedback from the community. FEMA is also required to document its decision-making process for this executive order by completing an 8-step process. This process ensures that FEMA considers all aspects of how a project will affect floodplains, and the final determinations and any conditions will be documented in the record of environmental consideration. As with other laws, such as the National Environmental Policy Act and National Historic Preservation Act, which were discussed in separate modules, this executive order is triggered by federal involvement. For FEMA, this typically means funding for projects. The next executive order we'll look at is Executive Order 11990 for protection of wetlands. It requires federal agencies to avoid adverse effects on wetlands to the maximum extent possible. This includes any activities that would destroy or degrade existing wetlands, typically caused by new construction or ground-disturbing activities. FEMA is required to consider alternative sites, and if that is not possible, may condition projects to mitigate impacts to wetlands through best construction practices. Additionally, as mentioned earlier, sometimes permits are required for work within or impacting wetlands. For projects with a likelihood to impact wetlands, FEMA must undertake the same 8-step decision-making process that was required for complex floodplain management projects, including a public notice period. The final determination and any project conditions will be documented in the record of environmental consideration as well. Lastly, we want to briefly go through some of the remaining laws and executive orders that EHP staff are required to consider as part of the NEPA review process that have not already been covered in this or other modules. The intent of each of these is to protect a variety of natural resources and regulate actions that could harm the environment or the public. The Migratory Bird Treaty Act was enacted to prevent unnecessary harm to migratory bird species. While the majority of FEMA-funded projects are found not to cause impacts to migratory birds, projects with large-scale removal of vegetation used as habitat or activities with the potential to obstruct flight paths, such as the construction of communication towers, may require special consideration and conditions. Next is the Fish and Wildlife Coordination Act, which was enacted to protect fish and wildlife from direct federal actions that control or modify a body of water. The key thing to remember here is that this law only applies to FEMA actions, not external applicants. Examples of direct FEMA actions include the construction of temporary housing or staging of federal equipment. If there are any concerns, consultation with the U.S. Fish and Wildlife Service or NOAA may be required. The Clean Air Act sets numeric limits on certain types of air pollutant emissions. The majority of FEMA-funded projects will not trigger Clean Air Act concerns due to the temporary nature of construction, but projects with significant debris burning or harmful airborne materials may require coordination or permits from state or local environmental agencies. The Wild and Scenic Rivers Act was created to preserve certain rivers with outstanding natural, cultural, and recreational values for the enjoyment of present and future generations. In Region 3, portions of 6 different rivers and creeks have been designated as wild and scenic, and projects involving work in or near those portions require consultation with the National Park Service. A link to the Wild and Scenic Rivers Mapper can be found in the Resources section of this module. The Coastal Zone Management Act of 1972, which was enacted to ensure federal activities in coastal zones are consistent with state management plans. Each coastal state has their own regulations governing development in coastal zones. Some require federal consistency reviews to be conducted for all FEMA projects, while others only require them for direct FEMA actions, similar to how the Fish and Wildlife Coordination Act is applied. It is recommended you work with your state's coastal management agency if you have specific questions, but again, FEMA's EHP staff can also help guide you if it is determined that a project requires further consultation. The Magnuson-Stevens Fishery Conservation and Management Act, which protects essential fish habitats that are used for spawning, breeding, feeding, and growth of commercial fish species. Essential fish habitats most commonly occur within salt, estuarine, or tidal waters, including marinas and harbors. Some freshwater areas, however, are essential fish habitat for diadromous fish species, such as salmon and sturgeon, among others. The National Marine Fisheries Service is the lead agency for this law, and FEMA projects near essential fish habitat may require consultation. Actions that may require consultation include construction work and other ground-disturbing activities, and work in or near waters containing essential fish habitats. As with the Clean Water Act, best construction practices regarding erosion and sedimentation control measures may be required to mitigate impacts to essential fish habitats. The Resource Conservation and Recovery Act, commonly referred to as RCRA, regulates the storage and disposal of hazardous solid wastes. For FEMA projects, this is most often triggered when commercial structures are demolished. When this occurs, the applicant is responsible for determining the presence of hazardous or toxic materials and following state and federal regulations to ensure proper handling, management, and disposal. Similarly, the state hazardous materials and solid waste laws are also used to regulate hazardous materials at the state level. It is most often a consideration for projects demolishing residential properties due to concerns of asbestos-containing materials. Once again, the applicant is responsible for following all state and local laws regarding handling and disposal. The Farmland Protection Policy Act requires federal agencies to examine potential adverse effects before approving activities that convert farmland to other uses. The lead agency for this law is the National Resource Conservation Service, and a consultation may be required if a significant amount of undisturbed land will be developed. A farmland conversion impact rating form may be required to help determine the effects of the proposed development on farmland. FEMA Region 3 EHP staff will work with NRCS to make the determinations, but the applicant will be responsible for providing accurate designs and measurements. The Coastal Barrier Resources Act, or COBRA, was enacted to protect ecologically sensitive and geologically vulnerable coastal areas, and federal agencies have been charged with preventing the loss of life, protecting natural resources, and preventing wasteful federal expenditures. COBRA is only a consideration for projects that fall within COBRA designated units. A link to the COBRA mapper can be found in the resources section of this module. The Fish and Wildlife Service is the lead agency for COBRA concerns, and they have developed a detailed process to determine which projects require consultation. FEMA Region 3 EHP staff are the ones who will determine whether a consultation is necessary, but again, it is the responsibility of the applicant to provide all locational and project scope details as necessary. And last is Executive Order 12898 for environmental justice, which prohibits federal actions that would adversely or disproportionately affect minority or low-income populations. The majority of FEMA projects do not trigger environmental justice concerns, but each one is still evaluated. In some cases, additional studies may be required for complex projects involving new debris locations, temporary housing, relocations of critical infrastructure, or construction of new facilities. FEMA is currently developing new guidance on environmental justice considerations, emphasizing the focus on equity and environmental justice coming from the White House. This slide has some resources available, specifically related to FEMA regulations and directives, the U.S. Fish and Wildlife Service's Endangered Species Mapper, the Pennsylvania Natural Diversity Inventory, which is also an Endangered Species Mapper for Pennsylvania, the FEMA Flood Map Service Center, and the U.S. Fish and Wildlife Service National Wetlands Inventory. This slide has some additional resources, including the Wild and Scenic Rivers Mapper, Coastal Barrier Resource System Mapper, and links to the 4 coastal zone management agencies in our coastal states. Thank you all for watching the EHP webinar series module for all other laws and executive orders.